So it's working now. The way the MC started is a bit, he started advising people to stay away from me. Good morning. Professor Adjolohun Horace, the head of the legal division of the African Court on Human and People's Rights, representing His Excellency Judge Blaise Chikaya, who is the president of the African Court on Human and People's Rights, Your Excellency Justice Nestor Kayobera, President of the East African Court of Justice, Mrs. Charity Hanenen Shimunya, Executive Secretary of the African Union Advisory Board Against Corruption, Your Excellency Ambassador Rena Lee, distinguished judges here present, distinguished lecturers here present, distinguished resource persons, representatives of regional, continental, and international institutions, dear participants, ladies and gentlemen, it's a great honor. It's a great honor and privilege for me to welcome you here. Before I proceed, I have the privilege and the honor to sit close to eminent personalities within the African Union system. I have the privilege to sit close to my sister, Mrs. Chimunya, who is the Executive Secretary of the African Union Advisory Board Against Corruption. And I have the privilege to sit with Professor Horace, who is representing the court, and my brother Nestor Kayobera, who is the president of the East African Court of Justice. I think it would not be justice for me to speak before the host of this event takes the floor, because we have been privileged to be allowed to use the premises of the African Court on Human and People's Rights to conduct this academy. So I would like to call upon the representative of the President, Professor Horace, to welcome all of us, and then we will proceed thereafter. You're welcome, sir.
Welcome to you all, and we are rather, as the African Court on Human and People's Rights, very much honored to have you here with us today, and I will later tell you why. You are home here, whether the Institute, the East African Court of Justice, or the AU Board Against Corruption. The African Court is the judicial organ of the African Union, And as such, when it comes to engaging on matters concerning international law, especially when it pertains to Africa, the best place, I would say, to engage on such issues is of course, the African Court on Human and People's Rights. Your Excellency Justice Nestor Kayobera, President of the East African Court of Justice, my dear sister, yeah, we meet again. And we are very much honored to have you here with us. Madam Executive Secretary of the African Union Advisory Board Against Corruption. My brother, we've been working together for quite some time. I met you when I came here in Arusha 10 years ago, in February 2016. You were here before me and you did welcome me. I want to appreciate that. Professor Matthias Sainkuye, Program Director of the Institute. All of you here, distinguished guests, distinguished participants, I want to sit on the protocol that has been stated by my brother from the Institute. It is my singular honor and privilege on behalf of His Excellency Blaise Chikaya, President of the African Court on Human and People's Rights, to welcome you to Arusha and here to the seat of the African Court on Human and People's Rights for the opening of the 2026 session of the Kilimanjaro Academy on African Union law and the public law of Africa. The African Court on Human and People's Rights has contributed in a unique way to the international law discourse on human rights, but also on a number of other related issues: the rule of law, judicial independence. Over the past 20 years, the court has been engaging with victims, with states, with civil society organizations, and has produced a unique jurisprudence that has contributed in a particular manner to public international law. For those of you who have been involved in research, those who are from the academia, and those who are from judicial institutions, you must have noticed, and I did, that most of the time when you go to a library or any other such places where you lay hands on a book on international law generally, and on public international in particular, you will notice one very particular thing. You lay hands on a book dealing with international law, public international law in particular, and the first thing you notice is that if there is anything at all that is said about Africa, it is quite slim compared to whatever is said about Europe or the Americas. And you ask yourself, therefore, the question whether Africa has contributed anything at all to international law. I know over the past 10 years, things have evolved a little bit, but I am proud on behalf of the African Court to have you today, because today's initiative shows very well that institutions such as the Institute have begun to also participate to this trend of changing Africa's contribution to the discourse on international law. That is that today, most of the books that you see dealing with public international law come from Africa by Africans, and you have entire generations of lawyers writing books and producing law. And you have institutions such as the Institute, but also the African Court, the East African Court of Justice, and other regional and international judicial institutions in Africa producing knowledge toward a greater and stronger contribution of Africa to the discourse on international law. Therefore, the fact that you gathered this morning in Kibo Hall feels to me entirely fitting. Kibo is the highest and most enduring of the three volcanic cones of Mount Kilimanjaro, the point at which every route up that mountain converges before the final climb to the summit. Over the 14 days ahead, you too will converge here from many countries, many professions, and many stages of your careers on a shared climb toward a deeper command of the law that binds these continents together. Arusha is, in its own right, a fitting home for that climb. Within a short distance of this hall sits the East African Court of Justice, the United Nations International Residual Mechanism for Criminal Tribunals, and this court itself, three institutions whose daily work is the patient construction of justice, accountability, and regional integration on this continent. Over the coming 2 weeks, your academy will take you into each of them. I mean each of these three institutions. Few cities in the world offer a legal education so thoroughly grounded in the very institutions it teaches. Allow me to congratulate, therefore, the African Institute of International Law on the vision and the sustained institutional effort behind this academy to assemble over a fortnight an opening lecture from a former president of the International Court of Justice, a sitting judge of that same court, sub-regional court presidents, senior African Union legal officers, and a distinguished faculty of scholars and practitioners of African Union law, human rights, trade, investment, and environmental law is no small undertaking. That the Institute has chosen to hold this academy within our own premises here at the African Court is, for this court, a source of genuine pride, and we are honored to serve as your host for these 2 weeks. This year carries particular meaning for us. In 2026, this court, African Court on Human and People's Rights, marks 20 years since it began its work of protecting human and people's rights across Africa, complementing the mandate of the African Commission on Human and People's Rights. 2 decades of jurisprudence, of advisory opinion, and of a patient effort to persuade our state that binding judicial protection of rights strengthens rather than threatens their sovereignty. It is fitting that this anniversary begins to remind us that of all years, we should be opening our doors to a new generation of students, scholars, practitioners, diplomats, and policymakers who will carry this project of continental justice forward. I do not think it is an exaggeration to say that a gathering such as this one is not merely useful, it is necessary. Africa at this moment is navigating a demanding period. Conflict and unconstitutional changes of government continue to test our Peace and Security Council and our regional mechanisms. And our union continues to insist, rightly, that constitutionalism and the rule of law are not optional extras, but the very foundation on which peace, development, and the dignity of the African person must rest. At the same time, the African Continental Free Trade Area is steadily reshaping how this continent trades, invests, and regulates across borders. raising legal questions that scarcely existed a generation ago. Our courts, regional and sub-regional, continue to grapple with questions of access, remedy, and the practical enforcement of rights that our states have on paper already agreed to protect. And at a moment of real strain on multilateral cooperation worldwide, Africa's capacity to speak with one coherent legal and institutional voice has rarely mattered more. It is striking, reading through the program prepared for you, how closely this academic contribution tracks these very challenges that I've just mentioned, from situating Pan-Africanism as the constitutional foundation of Africa's public law order, to the legal architecture of peace and security and the trade area, as well as its investment protocol, human rights and climate change, and ultimately to institutional visits that carry you beyond the lecture hall into the working life of regional justice and integration. This is not an abstract survey of African Union law. It is a real sense, a map of the terrain this continent must navigate in the years immediately ahead, and each of you is among the people who will help to navigate it. You could not ask for finer guides across that terrain. Over the coming 2 weeks, you will learn from most renowned African legal minds who have also either served or are still serving on the top world legal institutions such as the International Court of Justice, the International Criminal Court, or the International Law Commission. These distinguished faculty have shaped and continue to shape African Union law and the public law of this continent in practice and not only in theory. You will also step outside these walls to the East African Court of Justice, to the UN International Residual Mechanisms for Criminal Tribunals, the African Union Advisory Board Against Corruption, and the Pan-African Postal Union, so that what you learn here is tested against how these institutions actually function. To you as participants, I want to say, engage fully. Ask difficult questions, disagree where you must, with your faculty and with one another, and do so with respect. Build here the professional and personal relationship that will outlast this academy by many years, because it is often through such relationships formed over a shared seminar room or a shared meal that the real work of continental cooperation gets done. And when those 2 weeks ends, carry what you have learned back into your court, into your ministries, your universities, your legal practices, because that is ultimately how an academy such as this one changes a continent. Not only through what is taught in this hall, but through what its graduates go on to do with it afterward. Before I close, permit me to record our appreciation to Professor Matthias and the entire Secretariat of the African Institute of International Law for the evident care with which this academy has been organized, and to its partner institutions, including the Center for International Law of the National University of Singapore and Debevoise and Plimpton for their continued support to this initiative. We are grateful too to the African Union Advisory Board Against Corruption for its role in supporting the Institute. Distinguished participants, it is now my privilege to formally welcome you to the African Court today and to the 2026 session of the Kilimanjaro Academy on African Union Law and the public law of Africa. I wish you 2 productive, challenging, and rewarding weeks of learning, and I look forward in time to the contribution of each of you, the contribution that you will make to the law and to building a new discourse on Africa's contribution to international law. Thank you very much.
Thank you, Professor Ajolohom, for your kind words and very deep insights on what the participants should expect. And I'm also glad that maybe I want just to add one more aspect that possibly would also help to lessen or enhance the participants' knowledge. And I hope it will be part of the, could maybe the lecturers who will be lecturing should also consider if it is important. There are many questions about African narrative and African Renaissance on the aspect of the contribution of the African scholars in most of these issues of public international law. People talk so much about Nyerere doctrine of state succession, its contribution to the Vienna Convention on State Succession of 1978. But we talk a lot about restorative justices, processes, the transitional justice mechanisms that have also had a lot of contribution to how to resolve conflict at global levels. I hope some of the highlights could also help, to tell the African narrative that tells the African stories in the arms of the public international law. With these notes, let's help me to appreciate a very good statement from our host at the African Human and People's Rights by just round of applause. Can we clap for him, please? Let me also take this opportunity to welcome again Professor Matthias. Now, say something about the program. I hope that was just a welcome to Professor Ajolohom. I hope I'm pronouncing your name correctly. So, Professor, can you now tell us what we expect from the program before we proceed with the rest of the speakers? Thank you.
Your Lordship, Justice Nestor Kayobera, President of the East African Court of Justice, Professor Ajolohom, representing the African Court on Human and People's Rights, Mrs. Charity Nchimunya, Executive Secretary of the African Union Advisory Board Against Corruption, Your Excellencies, distinguished judges, dear lecturers and participants, ladies and gentlemen. My name is Matthias Sainkuye. I'm a professor of international law and legal scholarship. I am the director of the African Institute of International Law. Over the next 2 weeks, I shall have the privilege of serving you. Of course, with my colleagues from the Institute and the members of the Academy Secretariat, some of whom you have met already when you were registering, and you will have the services of my colleagues Alex, Irene, and Nema. I think I We have distributed also their phone numbers. Um, they will assist you with coordination, documentation, institutional visits, transport, and other administrative and logistical matters. I encourage you to approach any member of the team whenever you require assistance. We are here to serve you and to do everything reasonably within our means to make your participation productive, comfortable, and memorable. On behalf of the African Institute of International Law, I extend our profound gratitude to everybody who is present in this hall, as well as those who will join us remotely and those who will come here during the week and next week. Your presence here is not merely ceremonial. Believe me, it is an expression of confidence in the mission of the Institute and in the importance of strengthening the study, understanding, and application of African Union law and the public law of Africa. Some of you have traveled considerable distances to be with us. You have come from different regions of Africa and from other parts of the world, from the US, from Spain, from Germany, from Kenya, and from other African countries. I think I have to stress that among us, some are judges, others are public servants, others are prosecutors, lawyers, professors, and advanced students. This diversity is one of the academy's greatest strengths. It reminds us that African Union law is not a closed or exclusively African field of inquiry. It is part of the broader development of regional and international law, and it deserves serious scholarly and professional engagement from Africa and the international community alike. I wish to express our deepest appreciation to the African Court on Human and People's Rights under the distinguished leadership of its president, His Excellency Judge Blaise Chikaya, and the Registrar, Dr. Robert Eno, together with my distinguished brother, Professor Horace, for generously allowing the Academy to take place on its premises. There could be hardly a more appropriate venue for this program, you know. The African Court is one of the most important legal institutions created through Africa's collective commitment to human dignity, justice, the rule of law, and continental integration. And hosting the Academy here brings legal education into direct contact with institutional practice. It enables participants to study African public law not as a distant or purely theoretical subject, but within an institution in which African legal norms are interpreted, applied, and progressively developed. So the court's support is particularly meaningful because the Kilimanjaro Academy is being organized without dedicated external funding. I should stress this. It is essential that we do it because this arrangement is essentially a self-funded program. The African Institute does not presently possess the financial resources ordinarily required to organize an international academic program of this nature and magnitude. The Academy has therefore been made possible through the service, goodwill, and sacrifice of individuals and institutions that believe in Pan-Africanism and in the intellectual and legal future of this continent. It depends upon people who are prepared to contribute not only their knowledge, but also their time, energy, and in some cases, their own resources, so that opportunities of this kind may be created for the benefit of present and future generations. This spirit of service deserves to be acknowledged. Pan-Africanism cannot survive, you would agree with me, through declarations alone. It must be sustained by action. It must be sustained by commitment and sacrifice. It requires Africans and friends of Africa throughout the world who are prepared to invest themselves in building institutions, educating younger generations, developing African legal scholarship, and creating spaces in which Africa's laws, institutions, and aspirations can be examined seriously and critically. I therefore express our sincere gratitude to the African Court, to our distinguished lecturers and resource persons, to our institutional partners, to the members of the African Institute Secretariat, and to every person who has contributed visibly or quietly to making this academy possible. I wish to place on record our special and heartfelt gratitude to the French Ministry for Europe and Foreign Affairs, which, through the generous support of the Ambassador of France to Tanzania and the Director of the Alliance Française of Arusha, has made interpretation services available to us throughout the Academy. This invaluable contribution has enabled us to give practical effect to the Academy's bilingual and inclusive character, allowing English and French-speaking participants to engage fully with one another and to share knowledge across linguistic boundaries. In this connection, it is my particular pleasure to welcome Madame Creux-Laroche, Director of the Alliance Française in Arusha. Madame Creux-Laroche, we are deeply grateful for your presence and for the generous support extended to the Academy. We don't take this for granted. I also wish respectfully to acknowledge the distinguished personalities participating in this opening ceremony. We are deeply honored to be with you, Professor Adjoroun. Professor Adjoroun is a distinguished African human rights lawyer. He doesn't like saying it, but I wish to stress that he is a scholar whose work at the court has contributed substantially to the development and application of African human rights law. We are sincerely grateful to you, my brother, for welcoming us to the court and for conveying the court's message of support to the Academy. We are privileged to be with His Excellency Justice Nestor Kayobera, my good brother, President of the East African Court of Justice. His participation underscores the essential relationship between continental and regional legal orders and the indispensable role of African courts in advancing integration, justice, and the rule of law. We are very much honored by the participation of Mrs. Charity Hanenen Chimunya, my good sister, for many years, Executive Secretary of the African Union Advisory Board Against Corruption. Her participation and the presence of the board remind us that African public law must be founded upon integrity, accountability, responsible governance, and the principled exercise of public authority. We warmly welcome Her Excellency Ambassador Reina Lee, who is chair of the governing board of the Center for International Law at the National University of Singapore and Singapore's ambassador for international law. Ambassador Lee is a distinguished international lawyer and diplomat with more than 3 decades of experience in public international law. She notably served as president of the United Nations Intergovernmental Conference, whose complex negotiations culminated in the adoption by consensus of the landmark agreement on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. And she is also a member of the Permanent Court of Arbitration. We are deeply honored that she has kindly prepared a video opening statement for this year's session of the Kilimanjaro Academy. Her participation carries particular significance because the Center for International Law and the African Institute of International Law enjoy a close and valued institutional relationship. To all our distinguished guests, whether physically present or joining us remotely, please accept our profound gratitude. Ladies and gentlemen, the quality of an academy is ultimately determined by the quality of those who teach, those who guide and engage its participants. We are exceptionally fortunate to have brought together an eminent and internationally diverse faculty. His Excellency Judge Abdul Hawi Ahmed Yusuf will deliver our opening lecture on Pan-Africanism and the public law of Africa. This lecture will provide the intellectual and philosophical foundation for the entire academy. We will have Dr. Guy Fleury Ntwari, who will guide us through the law and institutions of the African Union, enabling participants to understand the Union's organs, competences, legal instruments, decision-making processes, and institutional practice. Dr. Ntwari has been delayed. His flight has been delayed. KLM has been canceling some flights, and we are waiting for him, expecting to see him this evening. Dr. Ntwari is a scholar and a practitioner of international law, a senior researcher and lecturer at Jean Moulin Lyon 3 University, and a former legal counsel of the African Union and director of legal affairs at the African Union Commission. His combination of scholarly expertise and first-hand institutional experience will be of exceptional value to the Academy. We will have Honorable Judge Dire Tladi from the International Court of Justice, and he will examine the peace and security architecture of the African Union, including its legal foundations, institutions, and contemporary operational challenges. And then we have Mr. Frank Hofmeister from the European Union, who will address the legal aspects of African Union, European Union relations, and the contribution of European Union practice to upholding and promoting international law. We also have the privilege and honor to be with Dr. Sotetsi Makong, who will lead our examination of the legal implications of the African Continental Free Trade Area, one of the continent's most ambitious legal and economic integration projects. As Director of Coordination and Programs of the African Continental Free Trade Area Secretariat, and as a specialist in international trade policy and trade law, Dr. Makong brings to the Academy both deep technical expertise and direct experience of the continental processes through which the African Continental Free Trade Area is being implemented. And during the second week, we will have Professor Obiora Okafor, who will examine the legal framework for the protection of human and people's rights in Africa. We will have Professor Hajer Guldich, who is the current legal counsel of the African Union, who will guide us through African legal instruments on environmental protection and climate change, a field of growing existential importance for Africa and the world. Then we'll have Professor Walid Ben Hamida, who will address the African Continental Free Trade Area Protocol on investment and its implications for investment governance, sustainable development, regulatory authority, and the protection of investments in Africa. We are proudly grateful to all these distinguished lecturers for accepting our invitation and for contributing their time and expertise to the Academy, and I stress they have accepted to do this at no cost. As I told you, the African Institute of International Law does not have funding, and we rely on people of this kind. The program has been deliberately designed as more than a conventional series of lectures. Over the next 2 weeks, participants will engage in lectures, interactive discussions, questions and answers, daily reflection sessions, and professional networking and institutional learning visits. And during the second week, we shall visit a number of institutions. We will visit the United Nations International Residual Mechanism for Criminal Tribunals. We will visit the East African Court of Justice. We will visit the African Union Advisory Board Against Corruption. And we will visit the Pan-African Postal Union. And all these visits are intended to connect legal principles with institutional mandate and practice. The Academy is founded on the conviction that African Union law and the public law of Africa must become more visible, more systematically taught, more rigorously researched, and more effectively applied. This is one of the missions of the African Institute of International Law, because for judges, this field provides essential tools for interpreting, applying continental and regional legal instruments. This is for judges, for civil servants and diplomats. This arrangement strengthens the capacity to implement African Union decisions, treaties, and protocols and policy frameworks. And for lawyers and practitioners, it opens new areas of professional engagement in litigation, arbitration, regional integration, trade, investment, human rights, environmental governance, and institutional advisory work. And for academics and researchers, it offers a rich and still developing field of scholarship that calls for distinctly African perspectives while remaining open to comparative and international engagement. For students and emerging professionals, it offers an opportunity to understand the institutions, norms, and ideas that will shape Africa's legal and political future. I therefore encourage every participant to engage actively. My brother, Professor Horace, spelled it out. He advises you to ask questions, share experiences from your respective countries, institutions, and legal traditions. Challenge ideas respectfully. Build professional relationships across borders and languages. The academy should not be a place where knowledge flows only from lecturers to participants. It should be a genuine community of learning in which every participant contributes. The academy will be conducted in English and French. This bilingual character is an important expression of our commitment to an inclusive African legal community that transcends inherited linguistic divisions. I encourage participants to use this opportunity to interact across linguistic, regional, and professional boundaries. Ladies and gentlemen, we gather here in the name of a conviction that Africa's integration, peace, prosperity, and dignity require that the development of African public law cannot be left exclusively to governments or institutions. It is a shared responsibility involving judges, lawyers, civil servants, diplomats, scholars, researchers, the students, you know, and all those who believe in Africa's capacity to construct a just and rules-based continental order. May these 2 weeks deepen our knowledge, challenge our assumptions, strengthen our professional networks, and renew our commitment to the service of Africa and humanity. Once again, I welcome you most warmly to the Kilimanjaro Academy on African Union Law and the Public Law of Africa. I wish you all a stimulating, a fruitful, and most of all, a memorable academy, and I thank you very much.
Round of applause again for Professor Senkuye. Next in the program will be, is it on, technician? Oh, thank you. We will have intervention from Judge Fascia Waguz, who is the lecturer of the African Institute of International Law, and she'll be joining us we have a minute to reflect on something. Hello. Let me now take this opportunity, instead of inviting Judge Fascia to join us, I will instead invite Professor Senkuye to welcome Judge Aldakawi Yusuf to speak to us. But before Judge Yusuf join us, I wish if Professor Senkuye would say something about him. And this is a judge whom I've had a privilege to attend his lectures, and I can assure you, if you had a plan to go out for a few minutes, you'll be missing something very big. So, Professor Senkuye, please say something about the Judge Yusuf, who will be joining us online. Thank you.
Thank you. Judge Yusuf, his CV is huge. But let me tell you this. The African Institute of International Law was established at the initiative of Judge Yusuf. It was established in close collaboration with the government of Tanzania, but all the thought and the groundwork was done by Judge Yusuf. He is the former president of the International Court of Justice. and he is currently the president of the curatorium of the African Institute of International Law. He is doing a great job for the sustainability of the institute and to assure that it has strong foundations and sustainable future. So it's my privilege and my honor to welcome him to join us. And I'm told he is ready, he is online now. Good morning, Judge Yusuf.
Good morning, I hope you can hear me.
Yes, we can hear you, as we say in French, 5 sur 5. And we are happy that you have joined us. We are gathered here at the African Court on Human and People's Rights. We have a big team of judges, lawyers, prosecutors, civil servants, and researchers, academics, and advanced students from Africa. We have participants from outside of Africa, from the US, from Germany, from Spain. So we have a good team, and we have started. We have been welcomed by the African Court on Human and People's Rights, and I have just given the audience a brief explanation and brief details on the Kilimanjaro Academy and of course on the Institute also. And we are very happy. The participants are waiting to hear you. They are impatient actually, because most of them have heard about you, some have seen you, others have even met you. So Your Excellency, you are most welcome and you have the floor.
Thank you very much, Professor Sankuye, and I'm very happy to be with the participants of the Kilimanjaro Academy on African Union Law and the Public Law of Africa today, and to say a few words on the background to the Academy, because the reason why the Academy was created and the reason why we have made it an annual event is actually grounded on the third phase of Africa's encounters with international law. And I will explain that. Because we have to explain in a way and understand better why we have an African Institute of International Law and how Africa participates or is affected, is impacted by international law. It has not always been impacted by international law, or it was at times impacted in a negative manner by international law. But what I mean by the third phase of the encounters of Africa with international law is because the first encounter of the African continent with international law was a negative and not a positive encounter. And of course, at that time, international law is not what we call international law now. It was actually a regional law of Europe. And the Europeans referred to their regional law as international law or the law of nations. Other regional legal systems existed in the world, but there was no universal international law that was applicable to all the nations of the world. We did not have the same type of interactions, of interconnectedness, which we have today in the world, which normally people refer to as globalization. But some sort of globalization started with the conquest by Europe of foreign lands and the colonization of Africa and Asia. And as part of that colonization, the European countries used their regional law, to which they refer it as international law, or the law of nations of Europe, in order to justify their occupation of the territories of the African countries and African peoples. And so they created certain legal concepts, such as terra nullius, which means that it is a kind of an unoccupied territory and a vacant kind of territory, which has no sovereign and therefore could be occupied by European power. Another concept which they created at the time in order to justify and facilitate their colonization of African territories was the concept of constitutive recognition. By constitutive recognition, they meant that you are not a state. The concert of Europe or the countries which belonged to the concert of Europe recognized you as such. So African political entities, African kingdoms, African empire, African states were actually not recognized as states. They were not recognized as members of the international society. They were referred to as non-civilized or barbarian nations, and therefore they were put outside the scope of the protection of international law, or what was referred to at the time as international law. And so their peoples could be oppressed, their territories could be occupied, their land could be spoliated, and their properties could actually be confiscated. And that is what happened exactly. And that was the first encounter of African states with international law, or with the use, I should say, of international law to justify oppression, to justify colonization, to justify occupation. The first reaction of the peoples of Africa came from the African continent, who objected, some of them using actually force to resist. But the most effective, perhaps, resistance, especially in legal terms, emerged with the Pan-Africanist movement. And that is why we are talking about Pan-Africanism and the public law of Africa today. Because Pan-Africanism actually is the best tool or the best concept which can enable us to explain and to research and to understand the diverse encounters of African continent with international law. The first Congress of the Pan-Africanist movement, which was held in London in 1900, did not actually include any participants from the African continent. Almost all the participants were diaspora Africans who came from the Caribbean and from the United States or the United Kingdom. They were people whose ancestors were enslaved and taken across the Atlantic to work in the plantations, in sugar plantations and other types of plantations, and therefore contribute to the economic development and economic growth of countries of the Americas and of European countries, and therefore they had suffered through several generations, and they knew what oppression and colonization would also, how oppression and colonization also would affect the peoples of Africa. And so they initiated a movement, the Pan-African movement, and they held their first Congress in London. And in that Congress, they did not really raise the issue of the self-government or self-determination of the peoples of Africa, because perhaps they were not acquainted with it, but they raised the issue of the land, because the British government at the time was expropriating the land of African communities in West Africa and in Southern Africa. And this land was being taken over by British settlers. And so the issue of the land was at the top of their agenda, and they wanted to appeal to the countries of the world and to the powers of the world to respect the land laws of Africa, to respect the property rights of the peoples of Africa. And their main argument was an argument that was put forward by a famous Ghanaian lawyer, Casely, at the time, who actually to explain to the British Parliament that there was a difference between the territorial cession or the cession of sovereignty by the kings of the Ashanti and other kings in Ghana to the British throne, ownership of the land. He explained it to them that according to African customary law, the land did not belong to the king, as was the case in the United Kingdom, and that the king could not therefore give away the ownership of the land in Ghana at the time, or in West Africa in general, because he actually argued also against the expropriation of land by the British in Lagos, Nigeria. And so they were trying to explain to the British Parliament and to the British public that what they were doing in West Africa, in Southern Africa, was illegal under customary law of the African countries, and that they should stop expropriating the land because the land did not belong to the king, and the king could not actually cede land. He could cede perhaps his sovereignty, but he could not, which is imperium, but he could not cede the ownership of the land, which is dominion, to foreign powers, and that the land belonged to communities or to individuals. And it was up to such individuals or communities to cede or sell their land, but it could not be illegally expropriated. But they soon moved it, the Pan-African movement soon moved it to government and self-determination, because in 1919, they held their second Congress in Paris, while the Versailles Conference on the creation of the League of Nations and the negotiations on the covenant of the League of Nations was going on in Paris. And so they call it on the powers in that conference to consider the rights of the peoples of Africa to self-government. And it is from there that they took up, actually, the issue of the self-determination of people. Because President Wilson of the United States was putting forward self-determination as a political concept. But in his view, it was to be applied to the peoples of Eastern Europe, to the empires in Eastern Europe, the Austro-Hungarian Empire, the Russian Empire, which became at that time the Soviet Union, the Balkans. And therefore, he thought that these people should be allowed to determine their future and destiny. But he never had in mind a principle of self-determination as a legal principle, which would be applicable to all the peoples of the world. And particularly, he did not have in mind its application to the peoples of Africa. But the participants in the second Congress of the Pan-African movement put forward the concept of self-determination as a principle of international law. And they said that the indigenous peoples of Africa should be allowed to govern themselves, and that they should be allowed to choose their own government. And that was actually the basis of the origin of the principle of self-determination, that the peoples of Africa should be allowed to choose and to consent who governs them and who is their government. But of course, the colonial powers, and particularly the British Dominion in South Africa, in Australia, in New Zealand, and the UK itself, as well as France, were not convincing such a concept and the application of such a concept to African countries. And so the Pan-African movement had to continue its struggle and its promotion of the concept of self-determination through the years until the Second World War, and until it was actually included in the Charter of the United Nations. So this was a second phase of the encounters the African continent with international law when the Pan-African movement first started try to influence the course of international law and the principles and norms of international law, and to use it as a tool for the liberation and for the self-determination of the peoples of Africa. And then this second phase stretched and continued into the independence of the African states and their emergence at the international level as states, members of the United Nations, whereby they could actually contribute to the establishment and elaboration of rules and principles of international law, and therefore influence the evolution of international law. And this is the essence of the second encounter of African countries and peoples with international law, the period in which they tried not only to influence, but to reform the principles and norms of international law in order to bring it into conformity with the rights, the perspectives of the newly independent states, not only African states, but Asian and Caribbean states. And for that purpose, of course, they used their solidarity, coordination with Asian countries and Caribbean countries in order to promote innovative norms, rules, principles of international law, and to elaborate further on the principles already contained in the Charter of the United Nations, and to see to it that those principles and norms would actually be enforced at the international level. So the first important, perhaps at the time, initiative that was taken by the African countries together with the Asian countries was to principle determination, norm, and as a right of peoples. And they did that, the adoption Resolution 1514 in 1960 by the UN General Assembly. Resolution 1514 is the resolution which actually established the right of colonial peoples to self-determination and to independence. And of course, they did not try to create the principle out of nothing. They proposed this and put it forward as a principle which should be recognized by all the nations of the world as a norm of customary international law. And that is what the International Court of Justice recognized and admitted in the Jagos advisory opinion in 2019, when the court said that Resolution 1514 was actually declaratory of international custom. And it was not a resolution which tried to create new law. It declared the existence of a norm of international law, the right of people to self-determination. And then, of course, from there, they went on to propose resolutionist and the codification of the norms of international law, taking into account the perspectives of the newly independent state. They spearheaded, for example, the resolution on the sovereignty over their natural resource. They spearheaded the codification conferences on diplomatic immunity and privileges, on consular. They spearheaded the codification conferences on succession of states to treaties and on the conclusion of treaties itself, the Vienna Convention on the Law of Treaties, in order to develop into the law in a written form the views and perspectives of African and Asian states, and not just to take into account the customs of European countries, which developed some of these principles in the 19th century and imposed it because of their military power at the time on the rest of the world. And so was the period of influencing and reforming international law, which was undertaken by African states together with the Asian states, and it continued into the 1970s and 1980s with the negotiations on the Convention on the Law of the Sea, which, as you know, the African states promoted the concept of the exclusive economic zone, which has now also become part of customary international law. So this was the second encounter. The third encounter is the one to which I address myself today, and that is with the creation of the Pan-African Organization. First, the Organization of African Unity, the OAU, and later the African Union, the AU. The African states started to develop their own regional law. And that is what we refer to as the public law of Africa here. We refer to it as the public law of Africa because it is not part of universal international law, and therefore calling it international law in the same way as the Europeans call it their public law, the 19th century international law would be misleading. It is the public law of Africa because it governs the relations among the African states. And it lays down principles and rules which address those relations. And of course, this public law has also to be read together with, but at the same time distinguished from the Union, from the law of the African Union. In my view, the law of the African Union is the law of the organization, the law which governs the functioning of the organization, like the constitutive instrument of the African Union, the law which governs its organs, the law which governs the various entities that have been established by the African Union, like the Pan-African Parliament, the African Court of Human and People's Rights, maybe tomorrow the African Court of Justice, the African Commission on Human Rights, etc. This is the law which governs the organs of the African Union, the law which governs the African Union and how it functions. But the public law of Africa is generated by the is generated through the African Union, but it does not deal with the organs of the African Union as such. It deals with the relation between states and peoples of Africa. And you can take as examples the African Charter on Human Rights. It creates obligation for African states. You can take as an example the African Convention on Refugees. You can take as an example the protocol, Maputo Protocol on women's rights. You can take as an example the Kampala Convention on displaced persons. And all of this, the public law of Africa. There are also certain principles, certain norms which are codified in the constitutive instrument of the African Union itself, which is part of the public law of Africa. And this is the regional law of the African country. It is international law, but it's not universal international law. But it interacts with universal international law, influences it, and of course, it can affect the development and have an impact on the development and evolution of universal international law. And this comes through, for example, the judgment of the International Court of Justice. Because if you take certain judgments of the International Court of Justice, which refer to the public law of Africa, which refer to the Charter on Human Rights of the African continent, which refer to the case law of the African Commission on Human Rights, to the case law of the African Court on Human and People's Rights, it means that these norms, these principles of the public law of Africa are actually taken into account at the universal level in order to settle disputes, for example, between African countries. And one of the cases in which these instruments were invoked and referred to by the International Court of Justice in its judgments was the case between the DRC, between Guinea and the DRC, and a case called the Amadou Diallo case. So, what are the main principles and norms of this public law of Africa? And it is going to be elaborated upon further by other lecturers, but I am just making these introductory remarks in order to give you the background to what you are going to study in the next 2 weeks, and to show you how actually the encounters of the African continent with international law have developed over the years, over the last century, I should say, from 1900 to our times, our period, and how they could further develop. They could further develop through exactly the public law of Africa. When African countries established certain principles and norms which govern relations amongst themselves, these norms can inspire the elaboration of similar norms at the universal level. Or the African countries themselves can propose that such norms should also be adopted at the universal level. And we have seen examples of that. We have seen to what extent the African Convention on Refugees, the Arusha Convention actually, because you are in Arusha and it's called the Arusha Convention. The Arusha Convention inspired the Latin American countries' practices and declaration on refugees, because the Latin American countries, in the same spirit, in the same way as the African countries, felt that the United Nations Convention on Refugees of 1951 was actually restrictive and was not and did not allow for a proper humanitarian treatment of refugees in the asylum country. And therefore, they actually inspired themselves on the Arusha Convention and took a number of norms and principles and concepts from the Arusha Convention. Therefore, bringing to the universal level the content of the Arusha Convention. So just to, because I don't think that I can take too much of your time. I know that you have the opening ceremony also, but just to give you a few examples. Let me start with the constitutive instrument of the African Union itself, because the constitutive instrument of the African Union contains an extremely important principle of international law, which is much more advanced and much more innovative than what existed at the international or universal level. The African Union has included in its constitutive instrument the principle of forcible intervention in member states by the organization in certain grave circumstances, namely genocide, war crimes, or crimes against humanity. The United Nations has been talking for a long time about the responsibility to protect. Here, in the case of Africa, a conventional principle, a principle codified in a convention, in a binding convention, a binding international instrument, but only for the African region, in which 54 African countries have accepted that, notwithstanding their sovereignty, state organs or some of the people commit these crimes against parts of the population, then the organization has the right to intervene and to protect the population. So, although the United Nations has actually announced and declared that there is, through a resolution, that there is a responsibility to protect at the international level, the only case in which the United Nations has taken some action, and that was for political reasons, was in the case of Libya, when some European countries decided to overthrow the regime of Colonel Gaddafi, and they intervened in Libya. And in order to justify their intervention, the Security Council and the UN General Assembly referred to the responsibility to protect, which was a resolution that was adopted before that time, but was never really implemented. In the case of the African continent, it goes beyond the principle of intervention, goes beyond forcible intervention, goes beyond the responsibility to protect. Its weakness, however, and I'm quite sure that this is the question that will immediately occur to you, is, has it ever been implemented in an African country? Have the 54 African states which subscribe to this principle and which actually say that if the people of South Africa are oppressed by their own government, are massacred by their own government, are their own government commits war crimes to humanity against them, then the other African states, their organization, come to the succor of these people, will come to their help and will protect them. This is what the principle says. But did the African countries ever implement it? No, they have not implemented. And a case in point today is the Sudan. This is where this kind of principle, this kind of norm should have been applied. Because we see the people of Sudan suffering. We see millions of people displaced because of violence. We see a war provoked by two generals fighting for power. And we see that the victims are the people of Sudan, which need to be protected. Is the African Union protecting them? No, it's not protecting. And this is the weakness of this innovative and looking principle that is included in the constitutive instrument of the African Union. But it's never too late to implement such provision and such principles, because it's quite possible that at the beginning the will does not exist, but the norm, rule, the principle cannot remain a dead letter forever. It will have to come to life, and it will come to life in the future, in my opinion. And it is for young Africans, African lawyers, African members of the legislatures of their country, the African judiciary, to actually invoke those kind of principles and to make sure that their government is implemented. Here, I was just referring to the innovative character, which actually exists only in a binding instrument in the African country. And actually, this is a characteristic of the third encounter of African states with international law, that they have legislated, they have laid down certain rules, certain principles which are more advanced rules or principles which you find in universal international law. But the problem, as is the case with this principle of forcible intervention in the African constitutive instrument, the problem is lack of implementation. And that is where the weakness of these norms, of these principles lies. Because it's good to enact the principles, it's good to adopt them, but they are binding, and binding norms should actually be applied and implemented. The second innovative principles, which you find in African instruments and in the public law of Africa generally, is the people's rights. You can find a reference to people's rights in the Universal Declaration on Human Rights. You can find it in the two covenants. But actually, the only instrument at national level which develops people's rights and elaborates on them is the African Charter on Human and People's Rights. It does not only refer to the people's right to self-determination or the right of peoples to self-determination. It refers also the right of peoples to economic and social development. It refers to the right of peoples to peace and security. It refers to the right of peoples to a healthy environment. And therefore, this is exactly with climate change what all the peoples of the world are claiming, a right to healthy environment. And with climate change, we may be deprived of that right. Therefore, you have to work towards the implementation of that right. And these are all people's rights which are contained in the African Charter on Human and People's Rights. And you do not have any equivalent rights which are contained in binding instruments at the universal level. Of course, you will find the right to development in a number of resolutions of the UN General Assembly, but you know that the resolutions of the UN General Assembly, unless they become part of customary international law, are only recommendatory. They are not binding on states. They have a recommendatory character. And therefore, they are not binding on states. But here, these principles, these rights are contained in a binding instrument, the African Charter on Human and People's Rights. So these are also innovative. This is another example of an innovative norm which is adopted within the context or in the context of the African public law, and which may contribute in the future to the development of international law, and it is part of the third encounter of the African continent with international law. Now, if we come to the rules and of course the conventions, the particular convention, we'll find, and I have already referred it to, we'll find the for the protection of refugees. It goes much further as far as the concept of a refugee is concerned than the 1951 United Nations Convention relating to the status of refugees. It provides a better protection for refugees, and I'm quite sure you will have an occasion to discuss it, how it does that. It recognizes a wider group of refugees, not only those who are persecuted for political reasons. So this expansive definition of a refugee in the African Convention extends this protection to all those persons who are forced to leave their country of habitual residence, nationality, or origin in order to escape violence, regardless of whether they are personally in danger due to political persecution, a much wider concept of refugee than the concept of refugee contained in the 1951 United Nations Convention. Is this also implemented to a certain extent? Implemented in most African countries. The African Refugee Convention is actually maybe one of the conventions that are best implemented, one of the conventions of the public law of Africa, which is best implemented in African countries. And it is mainly due to the fact that most African countries had to offer hospitality, asylum, and refuge to their brethren and sisters that were fighting independence in the 1960s, 1970s. And therefore, the issue of refugees in Africa is not only a recent phenomenon, it is an issue that was originally identified with the liberation movement in Africa and with the fight for independence. But now it is mostly due to internal conflicts in the African countries themselves. But even those who have to leave their countries, to flee their countries due to internal conflict, are most of the time welcomed and hosted by their neighbors until their country recovers or finds itself in a peaceful situation again. The second example of a convention which actually relates to the same subject is the Convention on the Protection of Internally Displaced Persons, which was concluded in Kampala in 2009. This is a unique kind of convention because at the universal level, there is no international instrument on the protection for the protection of displaced persons. And therefore, it is quite innovative. And it is something which could definitely inspire the adoption at the universal level in the future of a similar convention. You have only so far declarations on displaced persons, which have been adopted by the United Nations as in the form of resolutions, but these resolutions are recommendatory in nature. They are not a binding instrument, and therefore they are not as effective as the convention adopted in the African continent, and they do not advance the rule of law in the same manner. And the interesting thing about the Kampala Convention is not only that it is unique in its kind, but it is also very innovative in its content, and that is perhaps where it will not be equally at the international level. But I have no doubt that you will discuss about the Kampala Convention in some of your lectures, and you will have an opportunity to exchange on this innovative content of the Kampala Convention, which of course deals with displacement, not only due to conflict, but also due to a large development project and or projects relating to exploration and exploitation of natural resources, and protect the people who actually become displaced because of this project. A third example that I would like to give, and that will be the last example as far as the binding conventions are concerned, is the protocol, the African Protocol on Women's Rights. And it's possible that you will also discuss that and exchange on its content. But for the first time in an international treaty, uh, the African Protocol protects women's reproductive rights, including the right to abortion in the case of emergency, incest, or rape. The protocol also provides for the right of women to control their fertility. There is, of course, a United Nations instrument on the rights of women, the UN Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. And of course, it does not go as far as the African Protocol on the Rights of Women. Indeed, Article 14 of the African Women's Protocol, which addresses health and reproductive rights, goes beyond CEDAW in outlining reproductive rights. If implemented by African states, and I hope it will be implemented, it could constitute a tool for ensuring universal access to reproductive health for women in Africa. So these are some of the examples of the innovative approaches adopted by the public law of Africa with respect to universal themes, but universal themes which are not necessarily regulated at the universal level and have not yet become subject to rules and principles of universal international law. And of course, this is to the honor of the African countries that they should adopt and that they have adopted forward-looking and progressive rules of international law at the regional level. But what is missing, as I said earlier, is the effective implementation of these norms and principles. And I don't think that they will be implemented just by politicians unless the peoples of Africa themselves, because they have the instruments now. The instruments are there. Unless the peoples of the continent themselves fight for their implementation, unless the peoples of the continent, through their judiciaries, through their legislatures, through their, of course, political structures and mechanisms, and through the African Union itself, fight for the implementation and the application of these norms in reality. It's not enough to have them on paper, although it is already a major step that 54 African countries, sometimes a bit less, those who have ratified the conventions, but in the case of the constitutive instrument, there are 54 African countries that have subscribed to it and that have subscribed to the principles underlying it. In the case of the African Charter on human and people's rights, we now have the African Court on Human and People's Rights, which actually applies it. But there also, the weakness is that individuals cannot bring their cases before the court unless their respective governments have accepted its jurisdiction through a declaration. And the only countries that have actually deposited such a declaration of acceptance that individuals can bring cases before the African Court of Justice are extremely limited. At the last time that I consulted the list, there were only 6 of them that had made such a declaration. So the only way that cases can be brought to the court for the time being is through the African Commission on Human and People's Rights. But in order for the Charter to come into life and to actually ensure that all these concepts, all these principles and norms are applied. Most African countries and the majority of African countries need to make those declarations and to allow their peoples to go directly to the African Court of Human and People's Rights. Well, I will stop there because I have been speaking exactly for 1 hour. And I don't know what is the program, but if you have any questions, I still have about half an hour, and I can answer your questions in that half an hour. Otherwise, I will say goodbye to you, but I give the floor back to Professor Sahinkuya.
Thank you, Judge. Thank you, Judge Yusuf. Round of applause for him, please. Again, Honorable Judge Yusuf, we will take at least 2 or 3 questions from the audience in the interest of time, and maybe a moderator should have one. And one of the aspects that I wish to take to your attention is an aspect within the Constitutive Act of the African Union with respect to the decision by the African Union to intervene in Comoro in 2008. Some say the decision was more propelled by Tanzania involvement in the issue, and others commended the African Union as the first attempt by the African Union, and using the African Union instrument to intervene when Colonel Mohamed Bakal from the island of Anjouan decided to cede power from the island and take the island away from the Union of the Comoros. The second aspect is with respect to Congo, DRC, that although players who did intervention to get rid of the M23 in Eastern Congo, I think in 2012, and the subsequent decision of the African Brigade, which constituted Tanzania, South Africa, and Malawi, using the United Nations Security Council Chapter 7 mandate to fight M23. Would you partly call this an African sort of decision within the framework of the Constitutive Act of the African Union, with the respect that the players were Africans themselves? And then I will also wait for other questions from the audience if they have any in respect of the what you have just alluded to the audience. Karibuni, do we have any question from the audience? Okay. Can you give mic to
Thank you very much, Honorable Judge and Professor Yusuf. My question is on when it comes to regionalism, on this response to refugees, or what we can call also forced migration. Let's specifically focus on East African community. The statistics show that most of the refugees in East Africa originate from within East African community. What is the feasibility of responding as a region so that we don't continue with encampment, because it degrades the dignity and human rights of these people, our brothers and sisters, that we can try to embrace that Pan-Africanism? I know, of course, you have raised the challenge of implementation, and it still comes back, it's like a begging question, how can we implement these nice protocols and treaties, specifically in the East African community, for example? Thank you.
Thank you. Can we have another question? If none, we can ask Honorable Judge Yusuf to respond to those questions and maybe come back for the last bit of the maybe 2 or 1 question. So, Honorable Judge, please take the floor.
Well, thank you very much. And first of all, with respect to the constitutive instrument, the principle of forcible intervention is actually a noble principle. It is a principle which is anchored in international humanitarian law. Military intervention in countries where conflicts exist was carried out in the past because a major power wanted to do it and therefore wanted to take advantage of the chaos and conflict in a country. And it was not always well perceived, especially by countries that were colonized in the past. But the reason why the African states decided to include this in their own constitutive instrument is because they wanted to do it themselves and they wanted to avoid intervention by foreign powers. And when actually the European countries decided to intervene in Libya, the African Union tried to push back a little bit and say, this is an African problem, let us deal with it, we will deal with it, and you should not intervene. But unfortunately, the balance of power worked against them, and they were not able to prevent the European intervention with the support of the United States. Now, with respect to the initiatives which you have just mentioned, they were initiatives that were actually spearheaded by countries of a certain sub-region of Africa. They were not spearheaded by the continental organization itself. So we have, for example, other examples in West Africa. We have the ECOWAS examples in which the ECOWAS countries, and that was the most famous intervention, the intervention of the ECOWAS countries in Liberia, when Sergeant Doe took over power there. And, and that was a successful intervention, but it was not by the African Union nor by the Organization of African Unity. It was by a sub-regional organization. The Comoros also was spearheaded by Tanzania, and therefore it was not a kind of a continental initiative as such, but the continental organ blessed it and supported it, in the same way that they blessed also the intervention in Liberia. But what has not yet been implemented so far is that the African Union itself would actually, because it has now a peace and security organ, that the Peace and Security Council of the African Union should deliberate and decide that what is happening in a certain country requires the type of intervention that is laid down in the constitutive instrument of the African Union, mobilizes the necessary armed forces from the member states and intervenes as an African Union, not as a regional or sub-regional grouping of the African Union. Now, turning to the implementation of the Refugee Convention at the sub-regional level, at the East African level. Of course, it is up to the East African community to do that, and I think they can still do it. Because most of the refugees in the East African region actually come from Burundi, DRC, South Sudan, and Somalia. And all these countries are members of the East African community now. And therefore, the East African community could act as a community in order to facilitate the life and the access to protection of the refugees from all these countries. But up to now, they have been acting only as individual countries. And of course, they are allowed to act as such also, but in implementing and applying the Arusha Convention on Refugees, the African Convention on Refugees. Either way can work, but it is up to the member states of the East African community to decide whether their actions would be collective or continue to be individual.
Thank you, Honorable Judge, for your response. Maybe we get one more question. Thank you. Can you give a mic, please?
Thank you, Judge Yusuf, for the wonderful lecture. My name is Sydney. My question is, how is it possible that the African states that are very innovative in terms of establishing rights for its people beyond anywhere in the world, how is it possible that they do not demonstrate the same rigor when it comes to being held accountable, specifically with respect to direct access to the court by individuals and NGOs? Thank you.
One more question, maybe the last one. Honorable Judge, if you want to respond to that, to the question on...
Yes, I would say that this is something that, of course, will hopefully be done in the future, but it actually requires people like the participant who asked the question to press their respective governments and states to apply and implement what they have agreed to on paper, because it doesn't make sense to subscribe to binding instruments unless you intend to respect them. International obligations are binding on states. States should not take lightly the signature and ratification of international instruments. But up to now, it looks as though in the African continent, this has not actually sunk down. It has not yet become part of the culture of African countries. African countries subscribe to international conventions. They actually elaborate a lot of international conventions. There are now more than 70 instruments that have been adopted by the African Union and the Organization of African Unity, which are on paper. Many of them have been signed and ratified, but most of them have not been domesticated. They have not been included in the national laws of the countries concerned. And therefore, the judiciary does not apply them. So how is it possible that you become part of an international convention, international instrument, you subscribe to it, but you do not include it, you do not incorporate it, integrate it into your legal system so that your judiciary can apply? So these are the problems which African countries are still struggling with, and they have to actually make this part of their legal culture, because the legal culture is not perhaps developed enough in most of the African countries in order to make the government and the judiciary conscious of the fact that there are these principles, norms, and rules which need to be applied and which should be applied and need to be respected. But I hope that the younger generation that is now learning about this instrument, that is actually getting to know more about the instruments themselves, will do this in the near future. And this is one of the purposes of a training course like the Kilimanjaro Academy, is actually to create awareness among African lawyers, among African legal scholars, among African students of the law about this instrument, and that these instruments are waiting for their action. And I hope that such action will come in the near future.
Thank you again, Honorable Judge Yusuf. And I wish, in the interest of the audience present, when me and Professor Sekwe made a courteous call to former President Jakaya Mrisho Kikwete together with you, immediately after the conversation, one of the comments from the President was that if we were to have two people of your kind, Africa would be moving a very big step forward in the legal fraternity. And I wish to comment, I never gave you that feedback, but your talk today reminds me of the importance of the people of your caliber, you know, to inspire the younger generations. And I hope you will sustain the pace of having these conversations that really revolve around the African narrative. So thank you very much, Honorable Judge, for the insightful discussions that you provided, and I hope the audience benefited a lot from your talk. So round of applause for him again, please.
Thank you to all of you. Thank you. Thank you for your attention. And I hope that the next time I will be able to come in person to Arusha and participate in the academy. Thank you.
Thank you very much, Honorable Judge. Now, our next stage is we will have an intervention from Honorable Justice Nestori Kayobera, the President of the East Africa Court of Justice, on the reinforcing the importance of the regional court cooperations and integration in Africa. Justice Kayobela, please, karibu sana. I know you're rushing, but I'm sure you can still have some moment to...
Yeah, thank you. You know, because it is almost 12.
Thank you.
And after the lecture by my brother Justice Yusuf, I must be very brief. First of all is to commend my brother for this training. It's very important. You know, I'm just coming from Cameroon in a training which was organized by the African Union to some key lawyers on statelessness and nationality, which is always very important. So this kind of training is very important. And also, as the court, the East African Court of Justice, we are honored by the Institute because we have been participating in this kind of training. The Academy, of course, has been very instrumental to implementing the agenda of the community on the rule of law, access to justice, social justice, equal equality, and human rights. But because the participants will get opportunity to visit our court, I'm sure you will learn how the court has also implemented the agenda of the community, the jurisprudence, the number of cases against all the partner states. We have a number of cases, more than 400 cases have been already delivered, among almost 900 cases. So we have a number of cases which have been delivered against Tanzania, against Burundi, Uganda, Rwanda, Kenya, now even against Somalia and DRC. So now we have a very strong jurisprudence. So we welcome the participants to our court. We are very, very experienced people to share with you the experience of our court, but also We're also cooperating well with the African Court, but also with the UNHCR. So once again, I wish you well, but also fruitful deliberation. I'm sure the participants will gain much from with the 2 weeks of training. Karibu ni Arusha. Thank you.
Thank you very much, Justice Kayobera, for your intervention. And despite the very busy schedule, you were still able to come and, give us some insights on the particular training that we have today. And if I were to ask, if we are not rushing, if I were to ask why is the East Africa Court of Justice limited to interpretation of the law rather than many other aspects, I don't know whether you will have time or you will have to respond when they come back to visit your facility. I don't know which. I seek your indulgence, please.
I think it would be better when they will be
Okay,
there.
thank you.
Yes.
Okay, so can we clap for him again? Next in the schedule is the presentation by the Executive Secretary of the African Union Advisory Board Against Corruption, Madam Chimunya. She's a lady that I've always called my sister. Madam Mwashukeni. Thank you. So, Madam, please take the floor in alluding us to the role of the court and the role of the board, and the fact that you also exist in Tanzania. Karibu sana.
Asante sana. I think it's afternoon now. No, still morning. We still have a few minutes. A very good morning to you all. And let me begin by thanking the African Institute of International Law for the invitation to be part and parcel of this academy, especially the opening session. And I do look forward to welcoming the participants to the African Union Advisory Board Against Corruption the other week when you come. And in that session, I'll delve more on what the board does, how it does it, and what the board is all about. For today, mine was just a message of support. And as I deliver the message of support, it's a privilege for me to share the platform with distinguished sons of the soil, the two professors on my side, as well as the eminent judge of the African Court, the East African Court of Justice. I've already been introduced, so I'll just go straight and let me stand on the protocols that have already been established since the beginning of this, our deliberations today. It is a privilege for me to join you at the opening of the Kilimanjaro Academy on African law, African Union law, and public law of Africa. On behalf of the African Union Advisory Board Against Corruption, I congratulate once again the African Institute of International Law and its partners on convening this critical program, and especially under the circumstances you've convened it. You did indicate, Professor, when you welcomed us that the Institute doesn't have resources per se, and you've had to rely on well-wishers to be able to take off this academy. Congratulations and keep it up. And coming to the theme that is being addressed by the academy, the theme is very, very relevant and closely connected to the mandate of the African Union Advisory Board Against Corruption. African Union law and the public law of Africa cannot be fully understood without examining the principles of integrity, accountability, transparency, and responsible public administration. These are essential foundations of democratic governance, sustainable development, respect for human rights, and public confidence in state institutions. And ladies and gentlemen, distinguished judges present, you do recognize that corruption actually undermines these foundations. Where there's no respect for human rights, it's likely possible that corruption has had a stake in that. Corruption further diverts resources from essential public services, weakens institutions, distorts decision-making processes, and aggravates inequality. It also erodes citizens' trust in government and threatens the rule of law. Combating corruption must therefore be understood not simply as a matter of criminal enforcement, but as an essential dimension of constitutional governance and continental integration. This continent will not be fully integrated if corruption is allowed to thrive and rear its ugly face at each and every opportunity it gets. Your Excellencies, distinguished judges, ladies and gentlemen, the African Union Convention on Preventing and Combating Corruption provides a comprehensive continental framework for addressing this challenge of corruption. And to date, let me just divert a bit. The African Union Convention on Preventing and Combating Corruption has been ratified by 49 member states of the African Union out of the 55. So in terms of ratification, we stand at 49, and we are looking to universal ratification as time goes on. This convention, ladies and gentlemen, calls upon state parties to strengthen prevention, criminalization, international cooperation, asset recovery, and public participation. It also recognizes the importance of an independent judiciary, effective oversight institutions, a professional public service, a free media, and an active civil society. And the free media and active participation of civil society is actually key in fighting corruption as well as promoting the enjoyment of human rights. And as some of you may be aware, the theme for the 2026 African Anti-Corruption Day, I hope most of you know, as well as the upcoming African Anti-Corruption Dialogue, is premised on scaling up the promotion of integrity and anti-corruption measures across the continent to give effect to these legal instruments. And when you look at the theme of the African Anti-Corruption Day, as well as the dialogue and the issues that you'll be interrogating during the course of this academy, there's so much correlation, and hence the need to work closely with all of you as participants, as well as the institutions that are represented here today. When it comes to the legal instruments, we are cognizant of the fact that these legal instruments cannot achieve their objectives through adoption and ratification alone. And I think those that have spoken before me have alluded to this fact already. The effectiveness of these instruments depends upon implementation and domestication of the various provisions. And they must therefore be translated into strong national legislation, properly resourced institutions, credible enforcement mechanisms, and a culture of integrity throughout public life. And this requires political commitment, institutional capacity, and professionals who understand both the letter and the purpose of the law. And I'm glad to note that the Kilimanjaro Academy can make an important contribution in this regard, and especially that it brings together young people from the continent. It also brings esteemed judges from across the continent, scholars, diplomats, government officials, legal practitioners, and students. And it therefore creates an opportunity to examine how continental norms operate in practice, and how the gap between legal commitments and implementation can be reduced. Honorable judges, distinguished participants, ladies and gentlemen, in this regard, I want to encourage all the participants to approach corruption as a legal, institutional, developmental, and ethical challenge. And it begins at a personal level. What is your stance as a person when it comes to matters of corruption, preventing corruption? And so I also urge you to, as you go throughout this academy, to be reflective and cognizant of how corruption can derail even the academy itself and its intended objectives. I also want to urge you to consider how African institutions can cooperate more effectively, share good practices, and promote accountability at the national, regional, and continental levels. And for the African Union Advisory Board Against Corruption, we are pleased to support this initiative. We remain committed to working with academic institutions, courts, governments, civil society, and other partners to strengthen the culture of integrity and accountability across our continent. And as a people, I think we can do it together with our partners and supporters. On this note, and in the interest of time, I wish all the participants fruitful deliberations and hope that the knowledge and professional relationships that will be developed during this academy will contribute to stronger institutions and a more accountable, just, and prosperous Africa. An Africa that does not condone corruption. An Africa that is anchored on individuals and institutions of integrity. On that note, I want to wish all of you the best of everything, and I wish the Kilimanjaro Academy every success. Thank you very much.
Thank you very much, Madam Chimunya, the Executive Secretary of the African Union Advisory Board Against Corruption. That was so nice of you. The fact that you were able to come and the insights that you were able to provide, I'm sure will enrich most of the participants. And we are looking forward also for the subsequent participation and visit to your institutions, and maybe we could learn more. Round of applause for her, please. I wish now to invite another speaker, but we will play her video, Her Excellency Ambassador Rena Lee, whom Professor Sankuye was able to introduce him very well. I don't want to repeat, who will highlight on the role of the international law and multilateralism in promoting good governance and rule of law in Africa. So can the technician help me to play the video from Her Excellency Ambassador Rena Lee, who will also highlight, as I said, on the role of the international law and multilateralism in promoting the good governance and the rule of law. After the video, we will have...
Good morning.
Thank you.
Excellencies, ladies and gentlemen. My name is Reina, and I am the chair of the governing board of the Center for International Law of the National University of Singapore. On behalf of CIL, I want to express our great pleasure at partnering the African Institute of International Law in its executive program, the Kilimanjaro Academy on African Union Law and the Public Law of Africa. Here in our part of the world, Southeast Asia, we also have a regional organization. It is known as the Association of Southeast Asian Nations, or ASEAN for short. It is not as large as the African Union. It has only 11 member countries, and we are 58 years old. ASEAN law is one of the key research focus areas for the Center of International Law. One of our early projects was the ASEAN Integration Through Law project, and this was an ambitious project to examine the development of ASEAN through a comparative lens and how the rule of law underpins ASEAN. This project has resulted in a book series, currently at 18 books, and the ASEAN Law and Policy Academy, the latest edition of which was coincidentally just held last week. The annual ASEAN Law and Policy Academy, which first began in 2018, brings together participants from all over ASEAN member countries, whether they are government officials or practitioners or researchers or academics or practitioners, to discuss pertinent issues of law and policy concerning ASEAN in a variety of fields, including economics, the digital economy, human rights, dispute settlement, etc. The Academy is accompanied by a curriculum that's freely available for those interested in including elements of ASEAN law and policy in their own programs. Our experience within ASEAN has taught us that in the pursuit of our objectives, we must be aware of our place within the international community. The structures, the institutions, the laws and the norms that govern our organization are anchored within the wider international community. As such, external partnerships and cooperation are a big part of ASEAN's focus. And perhaps this may be the same for the African Union as well. To take our place within the wider international community, to engage in partnerships and to cooperate with those outside our organization, it means that we must find commonalities, some common basis. And I want to suggest that one, though not the only, common basis for partnerships for cooperation is international law. An understanding and appreciation of the fundamental principles of international law, such as the law of treaties. In ASEAN, we have a number of treaties with our external partners, a prime example being the Regional Comprehensive Economic Partnership, or RCEP for short. This is the world's largest free trade agreement linking ASEAN economies with partners in the Asia Pacific, namely Australia, China, Japan, Korea, and New Zealand. Even internally within ASEAN, an understanding of international law is crucial in our intra-ASEAN relations and governance. Fundamental principles of international law, such as those enshrined in the UN Charter, are the foundation upon which ASEAN can develop and advance. There are currently about 200 intra-ASEAN treaties in a wide variety of fields, primarily but not exclusively in the economic field. Such treaties govern relations between ASEAN member countries, but perhaps more importantly, they are also crucial for citizens within the ASEAN region and beyond conducting business within ASEAN, because these rules provide a clear understanding of how business is conducted within ASEAN. They smoothen the way for ASEAN trade, movement of goods and services, people-to-people exchange, having a common set of rules that member countries adhere to promote stability and predictability, providing a pathway for economic development that benefits the region as a whole. But ASEAN is not simply an organization that exists to develop rules. Equally important is that the rules advance the policy objectives of the organization. As such, there is also a need to focus on implementation and compliance with these rules, because this is what results in real impact on the ground. All this requires ASEAN member countries to work closely together. The ASEAN Charter provides for decision making by consultation and consensus. We call it the ASEAN Way. You may be wondering why I am referencing ASEAN when the Kilimanjaro Academy rightly focuses on the African Union. I see that both the African Union and ASEAN have some broadly similar aims: peace and security, cooperation amongst member countries, economic integration, to name a few. I think that there are opportunities for us to learn from each other as we seek to chart the future for our respective regions. I wanted to share our experiences within ASEAN in case they may be useful, not necessarily for what to do, but perhaps also what not to do. Maybe in future editions of the ASEAN Law and Policy Academy, we may welcome some of you to join us, just like perhaps in the future we may see ourselves joining you at the Kilimanjaro Academy. Today, our world is in a state of flux, and dialogue is more crucial than ever. Not simply dialogue between states, between government officials, even though this is important, but dialogue amongst practitioners, academics, researchers, and even simply the man or woman in the street interested in wanting to contribute to making our world a better place. Such dialogue can promote understanding, consensus, and cooperative action. And to my mind, this is infinitely preferable to conflict. Once again, CIL is pleased to be a strategic partner of the Kilimanjaro Academy, and I wish all participants a very interesting, fun, and thought-provoking couple of weeks. Thank you very much.
Professor, I don't know whether you have anything to say before we go for break.
What we're going to do is to take a group picture.
Picture at the terrace, just outside, just opposite this, the main exit door. So we would be more than happy if we could go first before our great people here, so that when they come, we should be lined already on the just the steps opposite the exit door. So can we do it quickly if you can?